Hello, welcome to Legal Action. My name is David Siegel. Thanks for joining us today. As always, my co-host, Jesse Barrientes. Jesse, how are you?
I'm doing fantastic, Dave. How about yourself?
I'm doing good.
Great.
Listen, the topic tonight is bankruptcy.
Oh,
You've
that's
got
a
Chapter
surprise.
7 and Chapter
Yes.
13. People are struggling, although things are starting to improve a little bit in the country. The jobs are increasing. Stock market is up. Real estate is up. However, when things go up, lending starts to open up, and people find themselves in trouble with credit cards, payday loans, unsecured loans, mortgages and cars that maybe they can't afford. So even when things are good or bad, bankruptcy is a constant. So we're going to talk about that today and help the viewers learn their rights and obligations and what's available for them under the code.
That sounds really good, Dave. I kind of wonder why our economy is on such an uptick. But let's talk about the two different chapters. You mentioned Chapter 7 and Chapter 13. Let's just talk about first Chapter 7. Then I guess, we can go back and, after we talk a little bit about that, talk about the other chapter. And Chapter 7 is what you call a fresh start?
What's known as a fresh start. Chapter 7 is the most common chapter. 3 out of every 4 bankruptcies is the Chapter 7 variety. And that's where someone who doesn't have a lot in terms of assets and a ton of debt, medical bills, personal loans, credit cards.
All unsecured. What if I have a house or a car? Can I bankrupt them and just keep it free and clear?
No, if you want to keep a house and a car, you have to continue to make those payments.
Okay.
Those are secured items. And by that I mean if you don't make the payment, the lender or the mortgage company can foreclose on the property and recover it.
But if I got sick and I don't have insurance for whatever reason, and I have a couple $100,000 in medical bills, I can get rid of all of that?
As long as you do not have significant assets, then you could eliminate this miscellaneous unsecured debt. That's the beauty of the fresh start. That's why the government put this bankruptcy protection in place. They didn't want you to be stuck with those medical bills and high interest credit cards for the rest of your life.
So then when would somebody want to file a Chapter 7?
You want to file a Chapter 7 if you're overwhelmed with debt. That's the bottom line. If you have the ability to pay off your debt in 3 months, 6 months, maybe even a year with a payment plan, then you don't need to file. But if you're at the point where you cannot get out of debt, you're just fighting it each month and getting nowhere, then Chapter 7 is your best bet because you will clean the slate on most of your debts.
And Dave, this is true with not only Chapter 7, but also Chapter 13 as well. It's not just the financial issues and everything else. I know, you've done a lot of this, I have too, and don't you see a psychological and emotional toll on people when they're robbing Peter to pay Paul and they're kind of worried what's going to happen, and they get tons and tons of calls from all of these creditors that are really harassed and probably not even complying with the act.
Right. If you're struggling financially, it's affecting your sleep, in many cases, your ability to work because creditors can call you at work. You can't pick up your cell phone because you're getting all kinds of collection calls. So there is a drain on you. You start to feel like you're not functioning properly. It could affect your family life with your spouse or with your work or with your church. So it's best to take action and get the relief that you need so that you can be a better spouse, a better worker, feel better about yourself and your situation.
Well, what are in that kind of line there? What are the pre-filing requirements for Chapter 7 fresh start bankruptcy?
Well, the government put in some measures to make sure that people go through some steps before they can file.
So there's some hoops to jump through.
There are some hoops. The first is a credit counseling session, which has to be done before a case is filed.
So what's the purpose of that, and what do they deal with in that?
It's a 1-hour session on a computer or over the phone where a credit counselor is going to interview you, very similar to what you're telling your attorney when you come in for the
So
first
it's a
case.
live person.
It's a live person, or it's done over the internet, and then at the end you connect with a live person to talk about your situation. But here's the deal. Anyone who's doing credit counseling is getting that information from the bankruptcy attorney. So it's just an exercise that they have to go through, pay approximately $15 to a credit counseling company, and obtain a certificate enabling them to file.
Are they going to try to talk me out of filing bankruptcy?
They're not going to talk you out of it. They're going to evaluate your situation. In most cases, they're going to recommend that you're doing the right thing. But they can't really talk you out of it. They don't down-talk bankruptcy. It really is more or less an exercise with very futile results if the government intended on people to do the counseling and then not file. That's not happening.
Sure. Well, we talked about some of the pre-filing requirements and everything else, and talked about all of these people being able to call you and send you communication and correspondence and letters and at work and at different times, even though, again, the Fair Debt Collection Act places restriction on those things, but very often the creditors don't really, or the collection agencies don't follow those parameters. So what happens when I file a Chapter 7, or even a Chapter 13 for that matter?
Well, anytime you file bankruptcy, upon filing, there's going to be the creation of the automatic stay.
What does that do?
This is a big stop sign that tells creditors you cannot call, you cannot collect, you cannot attempt to collect on certain debts while the bankruptcy stay is in place. And that's set up in the system to give you the instant relief in most cases so that creditors stop calling, stop garnishing, stop lawsuits. It just wipes it out, puts a freeze on it while you're going through the process of bankruptcy.
What if somebody what if somebody continues to call me after I file that?
Well, like you mentioned, there's the Fair Debt Collection Practices Act, which prohibits certain types of collection activities. Plus, you've got the bankruptcy filing. So now you can go into bankruptcy court and bring a rule to show cause and try and hold that debt collector in violation and maybe get a monetary sanction for their abuse of the bankruptcy code by not adhering to the prohibitions of that automatic stay.
Generally, what type of debts are exonerated in a Chapter 7 bankruptcy?
Well, Chapter 7 is that fresh start. That's where someone doesn't have a lot of property. So we're going to wipe out credit cards, medical bills, personal loans, repossession deficiencies, mortgage deficiencies, utilities, any debt for a type of service. So it's a broad range of debt that can be wiped out under a Chapter 7 fresh start bankruptcy.
What survives a Chapter 7 bankruptcy?
Well, student loans at the present time are surviving a bankruptcy. This may change. There is legislation that's kind of going through Congress.
Wait a
and
minute,
different
Dave.
talks
I
about
paid
it.
my student loans off. I mean, I'm pretty sure that you did yours too. So what would, right now as we sit here and we're talking about this today, what would allow me to discharge my student loans?
Nothing right now, but I'm saying there may be
Nothing?
legislation pending. Student loans are here, non-dischargeable for the moment.
What if I got a loan from a bank that wasn't necessarily designated student loans and that's what I used to pay?
Anything for an educational purpose is non-dischargeable, with the exception, and I've never seen this happen, where you can convince the court that to keep the student loan on you would be an extreme and undue hardship. And in my experience, you have to be basically unable to work or function, and at that point, the student loan wouldn't be collecting on you anyway. So it really is a misnomer, in my opinion.
What's the type of legislation that's pending to lighten that up?
Well, the student loan debt, in terms of dollars, is out of control. So there's grumblings in the court and from people to try and come up with a way to help people who have student loan debt. There was a time, Jesse, where if a student loan was more than 7 years in repayment status, it was eliminated.
And that was in a bankruptcy?
That was in a Chapter 7 bankruptcy, but the law changed. I think it was in 1998, I believe. And since then, student loans of all different types and for educational purposes are non-dischargeable. So if you take out that student loan, plan on paying it.
So what happens then after you file your petition for Chapter 7 bankruptcy, right? Am I going to appear before a judge or somebody?
You are going to appear in front of a Chapter 7 trustee. Your attorney will be there with you, the trustee will be there, and any creditors have an opportunity to appear. It's really known as a meeting of creditors, which is mandated by the Bankruptcy Code, and the trustee just wants to interview you, ask you a series of yes/no questions.
Based upon your petition, right, to make sure that you've answered those questions and they're true and correct and accurate and you haven't left anything out. You didn't forget about that paid vacation property that you have in Maui.
Right. The trustee is doing an investigation on a very minor level based on the documents you filed to make sure that you qualify and that you don't have any significant assets that can be taken and administered to pay your creditors.
So in that case, you mentioned that it's a meeting of creditors and creditors can come. Why would a creditor want to come if I'm filing a Chapter 7 and it's pretty likely that it's going to be discharged, especially if it's something like a credit card, unsecured credit card debt, or a medical bill, or fees for services, or anything like that. So why would a creditor waste his or her time?
Well, most creditors will not appear. It's referred to as a meeting of creditors in the Bankruptcy Code, but typically creditors are going to let the trustee do his or her job to see if there's any assets to be administered. Where you may find a creditor appear at a meeting is if the creditor feels that there may be an asset or there might be some type of fraud, and they want to ask specific questions of the debtor with regard to those assets or information in the schedule.
So you mean like by fraud? It was, around Christmas Eve when I bought a very big, large, concave, flat screen television and some accessories there, and then come January 1st there, or 2nd, I filed a bankruptcy.
It could be a very large purchase, too close to filing. It could be a cash advance, too close to filing. It could be a transfer of an asset where the creditor knew you had a car because you put it on your loan, and then all of a sudden on your schedules, that 2016 Cadillac that you said was paid in full doesn't exist, and you didn't disclose it as a transfer. So there are things where people get into trouble with non-disclosure, and creditors can bring that to the trustee's attention.
Well, what property can I keep in a Chapter 7? Okay, so we've talked about, okay, I'm getting rid of all this other stuff, and it just seems to me that I probably shouldn't be able to have, an asset that's worth a ton of money and be able to discharge something that I owe that's also a significant amount of money.
Well, Chapter 7 bankruptcy is a very generous statute. It allows you to eliminate debt and yet keep a certain amount of property. Now, that's mandated by the Illinois statute, which allows you to keep up to $15,000 worth of equity in real estate, $2,400 of equity in a vehicle, all of your retirement as long as it's ERISA qualified.
So if I have $500,000 in ERISA qualified retirement, I get to keep all of that.
Yes, you also keep $4,000 worth of miscellaneous property known as the wild card exemption, which you can sprinkle over any type of personal property other than real estate. So you can file bankruptcy and keep a fair amount of property here in the state of Illinois. It's a very generous statute.
And in fact, in addition to the $15,000, that's per person. So if it's just me filing and not my spouse, obviously she has an interest. If it's in joint tenancy by the entirety or joint tenancy, she owns half of the undivided whole, and so half of that belongs to her, right? So that would be $30,000. So 15 and 15, would that be correct?
That's correct. Each spouse is entitled to an exemption if they're filing together. In the situation that you gave, the non-filing spouse still is entitled to their 50% share. So the trustee has to figure how much equity is available after I give the non-filing spouse their share.
Their share. So, and she's entitled to all that. So, well, let's say a situation where my in-laws are on the house too, because they contributed and bought my wife and I a house. Okay, so now we've got like 3 or 4 people on the property. Same thing applies. You just cut down the amount of ownership in that.
Right. The trustee needs to give all the owners their specific share, and then the trustee has to look into the cost of the sale. There's realtor fees, legal fees, insurance fees. What is the trustee actually going to net?
Title fees, right.
Title fees.
So it's really, even though it's $15,000 per person, you got a little bit more based upon all those other things, because it's not going to be worth it to sell it to realize $500 essentially.
That's right. It's going to be a little bit more because there's a cost of sale involved in these properties.
Well, okay, so a lot of people that I've talked to, they're wondering, okay, what happens when I file a bankruptcy? Look here, I have this Visa card that, Dave, it's zero. I haven't paid anything. Can I keep this card and continue to charge on that one?
Well, you cannot keep a card per se going through a bankruptcy.
Even though there's a zero balance on it?
Correct. You don't have to list that card because it technically is not a debt. However, the lenders, the credit card companies, they subscribe to a service that notifies them of recent bankruptcy filings. And they're going to send you a letter
they're going to clip
as the
my
cardholder.
wings.
They are going to cut your credit, absolutely.
So, well, okay, let's talk about that. They're going to cut my credit. Am I ever going to get credit again after I file a Chapter 7 bankruptcy?
You are definitely going to get credit again after a bankruptcy if you want credit. It typically takes about 6 months to a year to establish some forms of credit. You can purchase a vehicle financed immediately after filing, and you can get other types of credit after about 6 months to a year.
Wow, 6 months to a year. All right. So as time goes on, as long as I continue to pay, though, right?
Right.
That's what's going to happen.
You have to maintain good credit and not fall behind on other outstanding obligations.
How often can I file a Chapter 7?
You can file a Chapter 7, believe it or not, every 8 years.
Every 8 years?
Every 8 years. Now, hopefully when you file your first and only bankruptcy, you don't need to file again. But if you do, if things happen in life, maybe you lost your job, divorce, medical situation, you do have the ability every 8 years to file a fresh start Chapter 7.
Okay.
And if you're within the 8 years, there's a Chapter 13 option for you.
Option, and we're going to talk about that in a little bit. What is the 2-hour personal financial management class? And again, I just want to make sure we've talked about two things. We've talked about the initial class that people have to take, right, in a Chapter 7. That's true in a Chapter 13 as well.
That's right.
Okay, and so, and again, we'll talk about that, which is consolidation, partial repayment. And so what's also true with both of them, with both the Chapter 7 and Chapter 13, is a 2-hour personal, what is that, management class?
Right. One of the requirements before a case is officially over is a 2-hour personal financial management instruction course. And it's basically a 2-hour session that talks about everything from insurance, finance, purchases, identity theft, protecting your credit, all kinds of different things, just to give you a general kickoff to your new fresh start with a little bit of knowledge.
Okay.
Most people have said that the class is helpful as opposed to the credit counseling at the beginning, which they find was wasteful. The 2-hour financial management class, people do get something out of that typically.
Very good. Well, what does it cost to file a Chapter 7 bankruptcy, fresh start?
Well, it's going to depend. There's attorney's fees that range depending on the type of attorney, the experience level, and the service level. And of course, there's a court filing fee, which will vary. It continually goes up, but right now it is set at $335.
And that just is the filing fee.
That's just the filing fee that goes to the clerk of the United States Bankruptcy Court for the privilege of filing of a petition and getting out of debt.
Well, I mean, doesn't it seem, kind of wonderful to be able to spend $300 or whatever the attorney's fees are and to discharge $150,000 in unsecured debt?
Well, if you are someone who is in a position where you don't have the ability to repay and you don't have significant assets, then you can afford yourself for the relief. But people do not set out to file Chapter 7 bankruptcy. They don't say, boy, I'm going to run up some debt and then run into a bankruptcy attorney and pay a filing fee and an attorney fee and get out of debt. That's just not how it works.
Is my job going to find out if I filed a Chapter 7 bankruptcy?
Your job does not need to find out. They do not need to know. With the exception, if you're currently being garnished, then the bankruptcy attorney is going to send something to your employer notifying them to stop the garnishment. But your employer does not need to know about your bankruptcy case.
With that exception, obviously they know by implication, obviously, if they've received something like that.
Certainly the payroll department, the
Right.
human resources.
But not everybody. I'm not going to, bump into Fred and, hey, I heard you filed bankruptcy there, Unless Fred is, of course, in the human resource department, right?
Right.
Okay.
Right.
Dave, what is the Chapter 13? We talked about Chapter 7, fresh start. We have all these wonderful, options available. But what about a Chapter 13? What if I make a little bit too much money?
Think of Chapter 13 as a reorganization or a bill consolidation with strength. And by that I mean creditors will get notice of the Chapter 13. They have to file a claim, a proof of claim, to be part of the payout.
I filed plenty of those, Dave.
Yes. Now, if they don't file a proof of claim and the debtor finishes the bankruptcy case, those creditors get nothing. So it's very important.
What happens if you have a situation where you've got, and again, it could be a 10% plan all the way up to 100% plan. So generally, it's 10% plan for all of the unsecured creditors. That's what they're anticipated to get back. But only 1 or 2 creditors file a claim. Does that boost up the amount that gets paid to those folks?
Yeah, there's a whole mathematical, complicated formula. But basically, if it is a 10% payout proposed and not many creditors file claims, then the ones who actually file claims are likely going to get a much higher percentage than they would have gotten if everybody filed a claim. So it makes sense, Jesse, to always file a proof of claim. And you'd be surprised how many people don't file claims when they see that they might only get 10%.
Sure. When would somebody want to file a Chapter 13? What are some of the reasons?
The number one reason to file a Chapter 13 would be to stop a home from being sold at a foreclosure sale.
So when is the latest I can stop it?
You need to file that Chapter 13 before
the hammer
the gavel
hits
goes down on the sale.
Yep.
If you wait till after that, it's too late.
And you're done.
But as long as you can beat the actual sale date,
okay,
or the time of the sale, in fact, but don't wait that long.
Right.
Don't get that close.
Sure.
You can reorganize under Chapter 13. And I want to mention, too, that you're paying the mortgage arrearages over a 3 to 5 year period. So if you fell behind $10,000, you're stretching that out over 3 to 5 years.
But you're paying the current amount currently.
Yes, after filing, you have to make the regular payment again, which the lender will accept because they haven't been accepting it when you fell behind.
Right.
And then you'll make that arrearage payment through a trustee, which catches up, in essence, 3 to 5 years down the road, you're back to square one, you're even.
So then what are the pre-filing requirements for this Chapter 13?
You have to take a credit counseling session, just like in a Chapter 7. You have to provide 4 years of federal tax returns and 2 months worth of pay advices or paycheck stubs.
4 years. What do you have to do in Chapter 7? How many years of taxes?
Technically 1 year of taxes in a Chapter 7. However, the trustees are starting to ask for 2.
Okay. And we've talked about for Chapter 7 the automatic stay, and you had indicated that the stay is the same in a Chapter 7 or Chapter 13. That prevents anybody from trying to collect anything or really even to call you even.
Yeah, the stay goes into place when you file a Chapter 13 with a couple exceptions. If you have one Chapter 13 case that was dismissed within the last year, then the automatic stay only applies for 30 days. Your attorneys need to come in and extend that to all the creditors.
For any debt or secured debt or unsecured debt?
For any debt. And
So-
if you've had 2 cases filed, or dismissed rather, within a year, then there is no stay. Your attorneys need to come in on a motion to impose the automatic stay.
So if somebody filed a Chapter 7 or Chapter 13 bankruptcy and it got dismissed because they didn't pay or whatever, and then they filed another one, the automatic stay is only good for 30 days.
That is correct, but your attorneys will bring a motion within that 30-day period to extend the automatic stay
Which
to
will
all
be
creditors.
granted.
It will typically be granted, but the debtor needs to show the court what change in circumstances have occurred. In other words, why is this second case going to work when the first case failed?
Well, let me ask you this: if I had, if the person didn't pay, right, and I already know I'm a creditor and I filed my claim for my 10%, what can I garnish this person's wages to get to get my money back because the automatic stay is up?
I don't understand the question.
Okay, so if this person filed this the second Chapter 13 bankruptcy, okay, and so now her or his automatic stay is only good for 30 days. The attorney does not bring another stay. I'm free then to pursue that claim as a creditor.
It depends on the judge. There's some judges that say the automatic stay still applies against the property of the estate. It just doesn't apply against the debtor, which is a technical way of the judge saying you better come in on a motion to modify the stay anyway.
Right. Okay, so pretty much
be
it is
careful.
what it is. Sure,
Yeah, be
sure it is.
careful.
Okay, so what percentages pay back at a Chapter 13?
Well, it depends. It depends on the person's assets, liabilities, income, and expenses. If someone is just getting by and doesn't have a lot of assets, then 10% is appropriate. But if someone has a lot of equity in their home, or they make a lot of money, or they're way over the median income, then they're going to have to pay more than 10% back of those that file claims.
So on the low end of it is 10% of unsecured, okay, but you have to pay 100% of your secured creditors.
That's true with the exception of a vehicle. If a vehicle was purchased more than 2.5 years ago, you can pay the fair market value of the vehicle.
So basically, I lost it when I lost some value when I drove it off the lot. So I lost $10,000 in value. So if the fair market value now is $10,000 less, that is something I wouldn't necessarily have to pay.
As long as the vehicle was purchased 2.5 years before the filing. That's the key. They call it 910, which is the number of days it has to be purchased. If it's a 910 car, referred to that way, then we can lower the value or pay back just the value at 6%, which could be a huge savings between what the value is and what the actual dollar amount of the debt is.
But you have to at least have enough available monies after your allowable expenses to, within 3 years or 5 years, to pay back 100% of your secured debt, with the exception you mentioned, and a minimum of 10% of your unsecured debt. What happens if the money that's left after the allowable expenses doesn't kind of equate to that? What happens then?
If you cannot propose a plan that's going to pay back, like you talked about, then the plan or the case is not going to get recommended for confirmation, and it will be thrown out.
And then that's the end of that. Then I have to look at some other options.
Yes, or you can possibly refile if your circumstances change. Maybe you get additional income, you bring in some family member who's going to help you. So there's always a way, if you're creative and you work hard and you want to make it happen.
How do I pay the trustee in a Chapter 13?
Well, if you're gainfully employed, a W-2 employee, it's going to come out of your wages. Automatic payroll deduction.
What if I'm self-employed?
Self-employed, you're going to make the payment on your own via money order or cashier's check or even online.
What happens if I don't make the payment? Or if for some reason, I've had a busy month, Dave, and I wasn't able to make it. So what happens then?
If you fall behind on your trustee payment, the trustee or one of the creditors can bring a motion to dismiss the case or modify the stay to remove the bankruptcy protection. You will have an opportunity, though, to catch up. Your attorney can typically get a little bit more time for you, or you might be able to work out a repayment plan within the bankruptcy. So they're not quick to throw out these cases if
You
you're
have a
making
little bit of
an
time.
effort.
You got an opportunity to cure.
You do have time.
Yeah. What do creditors or will they object to my plan under the Chapter 13?
Some creditors will object, typically the auto lenders. Those are the ones that want to argue that the value of the car isn't correct.
That's what you mentioned, been able to reduce it, and obviously they don't want to lose out on that money.
Right. Or they want a higher interest rate, or they want a greater amount per month, which is known as a set payment. So yes, lenders can object, but mortgage companies just going to want their arrearage. That's a simple mathematical formula. But it's the auto where there's a little gray area where they want more than what's being proposed often.
Well, in addition to those, do I get to keep all of my property in a Chapter 13, or how does that work?
You keep all of your property in Chapter 13. You keep your house, you keep your car, unless you want to surrender those items inside the plan, which some people do. They realize they can't afford the house or the car, and
Well,
they
then
want to
what
give it up.
happens is that does it lose its identity then as secured debt, now becomes unsecured?
Correct.
In nature?
It becomes unsecured, just like a credit
Subject
card.
to 10% or whatever the plan payment amount is.
Sometimes less than 10% because the attorneys can propose a plan that would allow for satisfaction of the entire debt by way of surrender of the collateral.
And then you're out of that situation, takes care of that particular debt.
You're out of it completely if the creditor doesn't object.
Okay. Now, we had talked about applying for credit in Chapter 7. Is the same thing applicable in a Chapter 13?
Well, you have to complete your Chapter 13 before you're really allowed to apply and receive credit. So you're in a 3 to 5 year payment plan.
So I got to wait for 5 years till it's all done.
Yeah, well, you're holding your creditors off for those 3 to 5 years, so it wouldn't be fair for you to go to another lender and obtain credit. That's the theory there. You're really not supposed to get credit when you're in a Chapter 13, although some lenders have offered it and some debtors have taken it.
Well, what just happened? I mean, boy, 5 years seems like an awful long time. Can I get out of the case?
Sure, you can always dismiss the case.
Why would I want to do that?
Well, let's say you have some kind of family emergency and you don't want the money coming out of your check to pay Amex, Discover, and MasterCard. Maybe you need, for health reasons, a family member, something. You never know.
Would I be able to modify the plan?
You may be able to modify the plan depending
Based
on your
upon something
circumstances.
like that, if there was an emergency or something, could they switch it around?
No, it's still based on income and expenses. You can't use this other emergency as a reason to pay creditors less. But you do have the ability to dismiss your case, take care of your business, and possibly refile if the circumstance warrants another case.
Well, let me ask you this, and I think this is both applicable to Chapter 7 as, fresh start, as well as a Chapter 13 consolidation or partial repayment. What happens if I have an accident case, a personal injury case, and I'm expecting some money because my hand, Dave, isn't the way it used to be before the accident? Okay?
Well, depending on the chapter, there's certain exemption amounts. In a Chapter 7, you can keep up to $7,500 worth of assets,
in a
and 13 as well.
personal $7,500, that's it?
Yep, that's it. Good to see you, Jesse.
All right, Dave.
We got to wrap it up. We don't have any more time.
No worries.
We'll see you next time on Legal Action. Take care.
Thank you.